Hello everyone, welcome to our lecture number 8 for NCA Constitutional Law exam. So today we are going to cover a very important interesting topic. So topic number 20, when you look into the sample paper for this current year, the latest one, you will find a question related to this topic. So why I am saying this? Because if you are going to solve the sample paper, so you should have this thing in your mind that okay, we are getting this particular question related to religion from this topic. So topic number 20, freedom of conscience and religion. So the syllabus says that for this you have to examine Charter section 2A. So section 2A is important one. Then we have few important cases, judgment. So syndicate, Northcrest versus Amsterdam, then reference re same-sex marriage. So these two significant cases address the religious freedom issue. So firstly, we will be looking into the provision what section 2A says. So let's read this word by word. Section 2A of Canadian Constitution Act of 1982 guarantees the fundamental right. So right to conscience and religion. These two things are fundamental rights protected by the Canadian Constitution. Religion, we all know that. What is conscience? So this is one's inner feeling, what a person feels right or wrong. Inner moral goodness or blameworthiness of one's own conduct, intention, character. So, what a person feels about a particular situation, about doing something. So, all those things. If you want to do something morally, nobody can stop you. If you want to do charity, nobody can question you. If you want to follow particular religion, nobody can question you. So, your inner conscience, whatever you feel is right. Here, we are not saying that you are allowed to do anything illegal. We are just saying if you have belief in something, so that belief, that religion, both these things are protected by Canadian Constitution. So this constitutional provision serves to protect the religious freedom of individual. So here we are talking about individuals specifically, so corporations are not included, as well as their freedom of conscience, how they want to practice that particular religion, what are their beliefs, what are their views. So encompass beliefs that do not revolve around a deity or religious doctrine. So these are the other beliefs, the freedom of conscience ones. It imposes upon governmental body the imperative of observing religious neutrality. So every government body in Canada, whether it's a federal level government, provincial level government, they all should have a religious neutrality. They cannot be biased. They cannot discriminate any particular religion. Thereby uphold the principle of secular governance that everyone is equal, all religions are equal, every individual whosoever is in Canadian land has full right to follow their particular religion without any interference, without any question. Ensuring the state's impartiality in matters of faith, this cornerstone of Canadian constitutional law reflects commitment to pluralism. Pluralism is a kind of society where people of different mixed beliefs, cultures live together. So we are upholding this pluralism concept, protection of individual autonomy, individual freedom, personal choice in matter of belief and conscience. However, it is important to note that this particular section, like I told you, that you cannot do something illegal, or if government feels that something is justified for a democratic state, for the free and democratic society, and government is making anything provision, any reasonable limit to be placed on right and freedom, then those reasonable limit, if it is justified under section 1 Oakes test, then that is right. So this is particular exception. This section 2(1) is subject to section 1 reasonable limit. So government can put reasonable limit on rights and freedom if those limits are justified in a free and democratic society. They are required. While Section 2A protect religious freedom, conscience, these rights may be constrained if such constraints, restrictions are justified under Section 1. So freedom of conscience, we know that this section protects belief systems that are non-theocentric, means they are not related to any particular religion. So they don't fit any traditional religious classification. And second protection is related to direct religion. So for this, we have landmark case of R versus Big M Drug Mart. Supreme Court of Canada invalidated, negated the Lord's Day Act, which prohibited commercial activities on Sundays. So this act basically was deemed an infringement. It was against freedom of right. It coerced people to follow religious practices for sectarian purposes. So nobody can force you to do any particular thing that is infringing your freedom. So here case provided a definition of freedom of religion. So this case basically is important because it says us what is freedom of religion. Freedom of religion does not mean you are forcing someone else to follow something based on sectarian purposes. It means individual freedom, a person's individual personal freedom. Essence of concept of freedom of religion is the right to hold any religious belief one choose, right to express openly without fear of hindrance or retaliation, and the right to practice teach one's religion freely. So one's religion means personal thing here we are talking. So here Sunday observance was the main issue. So the purpose of Lord's Day Act was to enforce observance of Christian Sabbath. So this was the requirement. This is a Christian ceremony, so it was required forcefully for people to do. In R versus Edward book, Sunday observance was upheld. It was said justifies, but only because its purpose was deemed secular. So in this case, the purpose was not religious. So we have to see the difference. So it was recognized that the law infringed upon Section 2A because it economically penalized retailer who observed the Sabbath on Saturday. So law was upheld under Section 1 of the Charter and the Act included exemptions. It was also determined that the law pursued its objective using the least drastic mean. So it was least harm to people. So this is an exception. But here in Lord's Day Act, it was forcefully being performed from the people. So in R versus Big M, Justice Dixon stated that freedom of religion include right to manifest religious belief by worship practice as long as you are good to go with this freedom, as long as it is not harming anyone else. It is not infringing upon parallel right of anyone else to follow their own belief. Courts have moved away from the notion that freedom of religion only allow practice that do not harm other. There is now support. So there is one more thing that have been included recently by the courts, an unqualified right to act in accordance with religious belief, like blood transfusion for a daughter due to religious belief. So these kind of things, basically the kind of things, the kind of ceremonies you are performing under your religious belief, if those are harming someone, then you don't have right. So religious belief in itself again is subject to few limitation. Section 1, we know that. Now there are few other religious practices also that are not protected by this if they are providing harm to anyone, or if they are providing any parallel infringement upon right to religion. So in examination, how you are going to see whether a particular freedom of religion right has been infringed or not. First thing you have to see if there is a sincere belief that a particular connection nexus with religion is there, and the interference based upon that religious thing is small or big, is trivial or substantial. So you have to see this. So this kind of test for infringement of right has been established in Alberta versus Hutterian Brethren of Wilson Colony case. So first thing is there should be a direct link related to religion. Someone is doing something based on their religious belief. If that religious belief is being targeted by any government, then this right is in question. Then you have to get the protection from the charter under section 2A. So first thing is there should be sincere belief with the nexus of religion. Then you will perform a subjective test. Subjective test requires that the beliefs should be sincere, directly connected, so strong that you feel that okay, if this thing is someone is taking away from me, then my religion is at harm, is at risk. So it's very deeply connected to you. The interference is more than trivial or substantial. So it is more than a small interference. It is majorly affecting your religious belief. Then objective standard you can follow. A person cannot claim they feel the right has been interfered with. There has to be objective proof. So there should be a proof, evidence that government is interfering with their right in a way that is more than trivial. So first thing, a connection, second subjective test, third objective test. So if these things are being satisfied, there will still be section 1 reasonable limit analysis to see if that interference by government is justified or not. If not, if you feel that from the facts of the case that this justified is unreasonable, unrequired, then 100% you can go with your analysis and in your conclusion that here in this particular case such and such person's freedom to religion has been violated. So another landmark case that is mentioned in our syllabus as well, Syndicate Northcrest versus Amselim 2004. Orthodox Jews in Montreal had built small dwellings Jews lived in during a certain time on their condo balconies. Condo bylaw that had been approved by city prohibited any sort of construction alteration. So the condos that were being made by the local municipality, so there were few restrictions that you cannot change the structure of the condo balconies for aesthetic or safety purposes. You have to keep them as it is. Supreme Court held that bylaws violated their freedom of religion that was not saved by Section 1. Because here, where the Jews were living, they had small dwellings on their condo balconies, and this was related to their some religious belief. So court defined religious practice broadly, saying it does not need to be part of an established system of belief or religion, nor does it have to be belief system shared by other. Particular religious belief could be related to single person as well. When someone's, because in the definition you will see it is mentioned individual. So this section 2A is protecting your individual belief as well. It does not matter that something if related to Hindus, out of 100 Hindus, 99 say that okay, I do not believe that this is as per Hinduism. But one person is sincerely following and doing something based on Hinduism, based on his Hindu religion beliefs. So you cannot deny that person of such right. So Supreme Court in this case gave similar reasoning. It can be a belief that is unique, related to one particular person. This is a subjective test. All a person needs to show is that that particular person believe that this thing is there, that their belief is sincerely held. The fact it is new to the person is not relevant. A person can change their belief. So this does not matter. Then there is another case of movement like. So claimant regularly attended public meeting of municipal council of his city. At the beginning of each meeting, what happened? The major who would make a prayer and make a cross while saying in the name of Father. Like usually we see Christians who believe in the Jesus, they do that. So before starting any meeting, the major would make a prayer and make a cross while saying in the name of Father, the Son, Holy Spirit. Other city officials would do the similar action, but there was one person, the claimant, who filed case against this particular religious thing. He made that claim that he is uncomfortable as he himself considered to be an atheist. So major refused to stop this on the request of claimant. The claimant felt his right of freedom of conscience and religion has been infringed. So one thing is important to note down here, that freedom of conscience, it means your belief. So your belief could be that you don't believe in God, you are an atheist. So this is also protected by this particular section. So Supreme Court held that state has duty of religion neutrality. A government can never prefer any religion over the other, or even any atheist over the theist or theist over the atheist. So for a government to do such kind of activity in a government setup is not in consonance with section 2A. So Supreme Court held state has duty of religion neutrality. The state must not prefer, not hinder any religion belief including non-belief. They had neutral public space. must be absent of pressure. So government cannot pressurize anyone to confer particular religious belief. So this is exactly what we earlier read in Big Dart case. So another case which is mentioned in syllabus, reference re same-sex marriage. Section 1 of the proposed legislation said that marriage for civil purposes is lawful union of two persons to the exclusion of all other. Argument was that Section 1 imposed dominant social ethos that would be limit the freedom to hold religious belief to the contrary. This would force religious officials to perform same-sex marriage and would create a collision of right. For the first argument, court said the mere recognition of right of one group cannot in itself constitute violation of another. Second argument, court said granted right of freedom of religion protected against celebration of same-sex marriage. Forcing religious officials to perform same-sex marriage was not something the courts could see becoming a reality. So court said the potential of collision of right does not imply unconstitutionally. I would like to break down here the important things that you have to keep in mind from the previous case. So that case, number 1, it was in furtherance to an important Civil Marriage Act legislation enacted by federal government in 2005. Section 1 of this act legalized same-sex marriage. So this act included provisions that protect religious officials from being compelled to perform marriages that go against their belief. So this was direct acknowledgement of section 2A. So this particular section says that it's okay if someone wants to go for same-sex marriage, they are good to go, they can do that, but nobody can force the religious officials to perform same-sex marriage if they feel that it's against their particular religious belief. So here, this section is protecting religious belief of the religious official. So this is important. So this is direct acknowledgement of section 2A to ensure that religious freedom were respected while extending marriage right to same-sex couple. So at one side, federal government is providing same-sex marriage right, and the other side, in the same legislation, it is performing its duty of protecting the right to religion. So in this case, Supreme Court of Canada issued an advisory opinion regarding the federal government's legislation. The court confirmed that the federal government had the authority to define marriage and that extending marriage to same-sex couple was consistent with Charter 15, equality rights. But at the same time, it is also acknowledging Section 2A, the right to freedom of the religious officials who should not be compelled, forced to perform same-sex marriage. So this was important case. So now in examination, again, I would like to give you a brief because this is important topic. You might get a question on this. So if you're getting a question on right to freedom of religion based on section 2A, section 1. So first thing, you have to perform subjective test in your analysis, which will see the sincere belief. Number 2, you will see how much harm it is performing. The particular government action, is the interference more than trivial? Trivial means small. So it is like big nature, it is direct harm. Thirdly, if both are met, you can see that okay, there is a direct link between particular issue and person's religious belief, and the belief that has been interfered by the government is not a small belief, it is something that is very important for the person to follow further his or her religious belief. Thirdly, you will see whether that government action is according to Oakes test section 1. If not, then you can go further with your detailed analysis. So if both are met, section 1 analysis need to happen to determine if the infringement is justified or not in a free and democratic society. So this is how you are going to answer your question, and again all the important cases especially the three cases that are there in the syllabus, you have to mention those in your analysis. So those are important ones. So that was all for today. Thank you and good luck.